more so than just saying that, ensure that the additions and alterations are consistent with. I suppose there's a requirement that they don't compromise the heritage setting, but that's different from saying you want to change, I don't know, the electrical plugs inside and those sorts of things. Do you see that there's any potential issue around that wording, especially as it relates to the rules that we can come to in a minute, that there shouldn't be some mention of the significant values that the heritage item has, just to make it really clear?
Sorry, Commissioner, I was just unmuting. No, it all aligns with, you go from the definition of what additions and alterations are to be, and
yes.
then in terms of looking at the schedule, is the item that we're talking about an A or a B scheduled building, and
yes.
then referring to the heritage report for that scheduled building. That then gives you that whole picture of what the heritage values are for that item. And so in terms of looking at additions and alterations, you would then go through the consistency, bullet point 1, retain cultural and heritage values, that's your bullet point 2, which is set out.
Yes, okay, no, that's fine. I think that makes sense. I think it possibly arises more to do with the rules, and I'll leave it till then. Finally, two more things. Should this policy, or should the policy specifically encourage adaptive reuse? Because it seems to me that that's one of the practical ways that buildings that otherwise might be very hard to keep maintained to the standard that everyone would like, is to actually repurpose them in a way that's sympathetic to their heritage values, but also allows them to be used, quotes, constructively. You think that the policy framework needs to be more explicit about that?
Well, I think the policy framework could be more explicitly setting out the importance of adaptive reuse and reuse, but it does actually state it in A, 7.1.3a, when it talks about the contribution that historic heritage has, and through protection and conservation of its buildings, sites and structures, the district, sorry, I'm jumping around, I should read it properly.
No, it does mention reusing, but it's sort of in passing, sort of. And I'm just wondering, I mean, I acknowledge that it's there, but I would have thought that it would be important to encourage adaptive reuse quite strongly, so that these buildings, really, that can be a focus of ensuring their longevity.
Totally agree. Again, limited by scope of submissions.
Okay, no, that's fine. Thank you. And finally, can you just explain to me the rationale for taking away the reference to significance in G?
Oh, yes. So it really dovetails with the word features. So in terms of the framework of the both the operative district plan, the notified version of the proposed district plan, there is quite a clear reliance on significant features, which is a column in the schedule 30.1. And that significant features is very unique to each item, and it could be right down to a building has a bay window. And so when you then look at how you would track that through, that significant feature is really technically how the district plan is written at the moment, the only feature of that heritage item that really needs to be protected. So you could have something totally modern around that bay window. So removing significant features from G is to just remove that whole connection to that issue that the district plan presently has.
Shouldn't there be a reference, though, to Schedule 30.1 to the values that are identified there? Because there's been a very comprehensive effort gone into to identify what the values are, and yet not referring to them there by way of the change. Previously, I accept the point that it related to significant features, but it did say that we're identified in the schedule. Shouldn't this be protecting the value, not of the scheduled heritage? I suppose it does say the scheduled heritage items, but I'm not sure if that means the individual items that constitute the building, or whether that means the values that are identified, if you see what I'm trying to get at.
Yes, so definitely does not want to be, in my opinion, relating to specific features of an individual. It is the collective of the heritage values set out in the heritage report that's linked to the schedule that needs to be looked at. So I take your point. I mean, we could, one option would be to think about just deleting the words protect the significant features identified in, and then just retain the bracket Schedule 30.1 heritage.
Yeah, okay, no, that's fine. It would be, you agree that it would be perhaps helpful to reference, not just refer to scheduled heritage items, but refer to what the schedule says about them in some way?
Yes.
Okay, no, that's fine, thank you. If we can move to policy 7.1.4. Which is one that you haven't recommended any changes to, so I'm just going to put that on another screen so that we can see it. I just have to find it. Here it is. Has that changed the screen?
Yeah.
Yes.
You can. And that's now big enough, hopefully, that you can read it. Can I just ask, policy 7.1.4 relates to the two heritage precincts in the plan, Matangi and Huntly.
Correct.
Can you just explain to me why these are the only two precincts and why they've been picked for sort of special attention, and whether that's consistent with the rest of the plan?
So I will defer to Dr. McEwen on that matter, because that was part of her analysis in providing input into the district plan review process.
Okay, thank you.
So the reason that Matangi and Huntly heritage precincts are in the proposed plan is that they're simply rolled over from the operative plan. I was not engaged to identify heritage precincts for the proposed plan. And in fact, both the Matangi and Huntly heritage precincts, as they were notified, are problematic because all of the buildings in the Matangi heritage precinct are actually scheduled as, and I've recommended A rankings, and the Huntly heritage precinct is anomalous in as much as it doesn't include all of the former railway houses in Huntly West, and it doesn't have kind of any greater significance than the collection of railway houses that are scheduled in the plan in 30.1 in Ngāru Wahia. So this is a carryover from the operative plan. It means that it's only these two because I wasn't engaged to provide identify any other precincts, and it's now problematic for the reasons that I've just stated.
Thank you for that. Does that mean then that, given subject to the issues of scope that we've talked about before, you would actually favour deleting that policy altogether?
But, there's no scope to do so.
No, I said subject to scope, just in your expert opinions.
My view is that it would be preferable for Waikato District Council to take the same approach as Christchurch City during the replacement plan process, is to leave the door open for heritage precincts, but not to itemise any individual precincts until the work has been done to robustly defend those within the context of the plan. And as you'll probably be aware, Mr. Chair, with Christchurch, there was only one. There was the Akaroa heritage area that got rolled over, but basically Christchurch City left the door open for a significant piece of work to assess and identify and assess heritage precincts in order that they meet the assessment criteria in the RPS and give effect to the RMA.
So, Chair, it might be a good opportunity at this point just to hear from Ms. McConnelly with regards to the operative district plan, because they were rolled over, to understand why they got anchored in there. And so if I can just hear.
Well, we're not too interested in what's being rolled over. We're interested in what this plan says, I think. I mean, I can understand why they've been rolled over because they were there before, but what was done 15 years ago is not really that much interest to us. I don't think we can ask any more questions. I certainly understand the concept of saying maybe you can leave the door open to heritage precincts in the future, but that would require a plan change anyway, which would include any necessary policies to support it. So it seems to me that whether this policy was retained or deleted, subject to the issue of scope, is actually neither here nor there. And in an ideal world, it doesn't really serve that much of a useful purpose, I wouldn't have thought, for the reasons that Dr. McEwen's explained. But anyway, let's move on. I'm nearly done, I think, but I do want to talk about the rules briefly. We go to paragraph 281. Can I just ask, I mean, this is probably an ill-informed question really, but can I just ask why historic has been removed from rule 16.3.11 other than to make it consistent with some of the other ones? Given that the topics and the chapter is historic heritage, isn't it better to leave it in so that there's no ambiguity about what we're talking about?
I don't think it matters either way.
Okay.
Heritage
that's fine. No, that's fine. We go to page 114. To check the page numbers. Yeah. So we're going miles down. You'll be pleased to know. Oh gosh. Still got a way to go. These are the subdivision rules relating to the different zones. Can you just explain to me what the rationale for having a sort of an entirely different framework in the industrial zone is in chapter 20, which is this one here? I mean, I know it's still an RD and so forth, but why is there a different framework there than there is elsewhere in the district?
So it comes down to the submitter only asked for that change in that zone, which is I've addressed in paragraph 395.
Yes.
And
I won't go back to it because it's on the previous page, but yes.
So it does provide that cover with regards to significance, and that matter is being dealt with through your next hearing next week, I understand, on Maori sites of significance. So it was, my intention was to anchor it in there to ensure that we didn't lose sight, because it's been tagged to this hearing rather than the following hearing. But it does introduce a an inconsistency with the rules. I note that.
If we were looking to include specific reference to those Māori sites of significance, is that the place that we'd put them?
Possibly not.
Okay.
However, subdivision is your first port of call with regards to, you know, sometimes larger sites and the effects that subdivision does have on all heritage items. So, you know, the consideration of that comes back to, I suppose, what's the plan, how the plan manages Māori sites of significance.
Okay, all right, no, that's fine, I understand, thank you. Paragraph 414. This is really a drafting issue, but why, and again, the answer might be because of the scope of submissions, but why is P1, where I am here in chapter 17, different from P1 in chapter 24, for example, and some more on the next page? The reference, just for the sake of clarity, irrespective of whether there's any submission made, should refer to this tree removal certificate across the board, shouldn't it?
Yes, I'd agree with that. In hindsight, I should have done a sort of consequential change to ensure that that was then tracked through to the other.
Okay, no, that's fine.
Well.
Okay, that's fine. Paragraph 432, which is here. I just want to clarify what the ands and ors mean in here. The wording says is either. So just to be clear, it's either one or two, and in any event, the bits that follow on from that. That is the intention?
That's my understanding, yes.
That's how it meant to read. Okay, that's fine. This one's a little bit more substantive. This is a permitted, I'm at the top of the page, permitted activity rule, and it's the same in all of the rules. It seems to me problematic to have a permitted activity rule that says the tree work must meet best arboricultural practices, because who knows what they are and where are they specified. You know, my idea might be to hack at it with a chainsaw, and someone else says there's a whole lot of different techniques. How would you ever get certainty that something is best arboricultural practice?
I think the key thing would be if, and there is an if with this, that if someone asked council, they would direct them to engage an arborist to do the work.
Yeah, it doesn't say that though, and it doesn't, you know, it's a permitted activity rule. So theoretically you'd get on and do it. And I could see a real problem if someone starts, you know, saying, well, I think this is best arboricultural practice, and the neighbour has a fit, rings you guys up, and then you sort of send the troops out and tell them to stop. And they're saying, well, I'm just following what I think the rule says. I think it needs to be more certain than that, doesn't it?
Oh, I'd agree with that, yes.
Maybe you can give some thought to, to how that might be
Certainly.
fixed at some point. We can get that later. Paragraph 494. Can you just explain to me what the use of the two terms, where my cursor is, when we're talking about the heritage assessment criteria? It says the heritage significance and the value of the historic heritage. I think that should be have been assessed, but that doesn't matter. Why are the two terms there, and are they any different, and what do they mean in this context?
So I'll pass you to Dr. McEwen on that.
And perhaps I can just clarify what I'm saying, because when you look at the list, there's archaeological significance, and there's a whole bunch of significances in the list.
Yes.
And then there's some rankings, but there's no reference in that definition to values. And I'm just wondering why that is and what's intended there.
So I will ask Dr. McEwen to assist with the answer of that question. This does align with the criteria set out in the section 10 of the regional policy statement.
Yes.
And the best practice of setting out what the criteria for assessment is, and then identifying the two rankings used in the district plan. The significance and value, it is a term that is sort of interrelated and interused, but I will now pass to Dr. McEwen to provide technical input on that.
I'm not disagreeing or misunderstanding, I think, the concept of what you're trying to achieve. I'm really looking at it from the point of view of how things are worded. And, you know, when you've got a whole list of things that talk about significance, I see how that relates to the preamble to the list. But there's nothing in the list that talks about the value of the historic heritage against those. None of the criteria relate to, obviously, the question of value. They all relate to the question of significance.
I think in part, Chair, the issue is that the RPS actually, the assessment criteria are itemised under the headings of using the word qualities. So I think, you know, for clarity, it would be perhaps better here to say the heritage significance of the historic heritage has been assessed based on evaluation using the following criteria, and then just simply say archaeological qualities, architectural qualities.
I'm liking the sound of that much more because I can follow that. There's a logic to that, and I'm not sure that the same logic is quite inherent in what's there. So that's helpful. Thank you. I think that is helpful. Right, I've just got a couple of general ones that I want to ask now, if I may. And I'm not sure who from the council is best placed to answer this, but I want to get this on the table before we hear from the Kossuth family. Their submission relating to the Remu building in Huntly makes mention of an agreement with the council about the delisting of that building historically. And now it's popped up again in the proposed plan. And I'll ask the Kossuths when we get to them. But what can you tell us about, this is for the council, what can you tell us about the nature of that agreement?
Morning, Mr. Chair. I'm happy to address you on that matter. Staff have not been able to locate any agreement or any evidence that an agreement exists either in writing or orally. They have searched the property files of both 40 Main Street and their other property at 116 to 118 18 Main Street, but there was no evidence of any agreement on that matter. It is correct that under the previous 2004 draft proposed district plan, 40 Main Street was scheduled along with their other property at 116 to 118, and it does appear that following a meeting with council, the Main Street was removed. I have seen a letter from council to the owners of the property dated 21 June, which advises that their request to have 40 Main Street has been removed. However, that letter does not refer to any agreement, let alone an agreement of the nature that's alleged in the current further submission. And in fact, to the contrary, the letter specifically signals a possibility that council's decision to remove 40 Main Street from the plan prior to notification could be opposed by other submitters, and if that occurred, the owners would have an opportunity to lodge a submission on that change.
We'll come to the various Kossuth family members, and I've got to make sure I get the brother and sister part right, so I won't make that same mistake again. Although I'm sure I'm making half the family very happy and the other half entirely upset. But I'll try and resurrect myself later. So I just wanted to get that in the open so that you can respond to that when it's your turn, which will come up very soon. The second question, and this may be again one that you can answer, Ms. Parham, or maybe one of the staff. Am I correct to assume that when the various trees and heritage properties were included in the proposed district plan, that the owners of those properties were formally advised by council that there was a scheduling proposed on their land?
Yes, that's correct. There was a targeted letter to the property owners who had those listings on their property. That was a targeted letter in addition to just the general letter that went to the general ratepayers.
Okay, and I'll ask Ms. McKelly when she makes her presentation, but there's been a number of proposals for scheduling that weren't in the notified plan that have arisen as a result of submission, more specifically than anywhere else from Heritage New Zealand. Do you know if all of those properties that are potentially affected in that way are the subject of further submissions from the property owners, or that they were given the opportunity, other than reading in the newspaper, that there was a submission requesting scheduling of their property?
There's basically three groups of categories. So there is one group where the landowner did lodge a submission in support of the submission by Heritage New Zealand. There's a category where landowners lodged a further submission in opposition to the request via a submission for scheduling. And then there's a third category whereby a landowner's building was not notified in the proposed plan. A submission has sought that scheduling. The landowner did not either submit or further submit in relation to that scheduling, and now either the 42A report author or council's heritage consultant, Dr. McEwen, is recommending that the scheduling be included in the district plan. And we've carefully looked at the properties concerned in that third group, and there appears to be three landowners. It's the private owners of 19 Bow Street, Raglan, the private owner of the Taupri Post Office, and then council as the owner of 4 war memorials, and council as the owner of the Atahu War Memorial Bowling Club Gates and Boundary Wall. The council staff have looked at, I should say prior to notification, council staff through pre-notification consultation, council staff were aware that the private owners of 19 Bow Street and the Taupri Post Office were strongly opposed to having those properties scheduled in the district plan. It appears that when the Heritage New Zealand submission was lodged, that a staff member did contact those owners to advise them of a submission. However, we don't know whether the staff suggested to those owners that they should lodge a further submission. So we're not actually, we know contact was made. We know that to those 2 private owners, we know that the owners reiterated their view that they were opposed to scheduling, but we don't know what advice they were given, if anything. In terms of the asset managers of the council-owned buildings and structures, they were not contacted by these council staff to advise of the submission by Heritage New Zealand. So staff are not aware of their views on that.
That's very helpful, thank you. Can I just ask about Bow Street in Raglan? There is a submission from Raglan Properties Limited. Well, sorry, I'll start again. There's reference in the either the submissions or the proposed plan to 11 through to 19. And there's a submission from Raglan Properties Limited relating to at least some of those properties. And I'm not sure, are they the owner of some or all of those properties on Bow Street? And does it not include 19? Does anyone know that?
Are they the owners, I understand, of number 11? So
Okay, only of 11.
number 11's on one side.
19 is on the
Oh, sorry. They're the owners, Dr. McKeown has just clarified to me, they're the owners of number 19 and 11 is on the other side of the road.
Okay, and owned by somebody else.
Oh, I beg your pardon. Betty has just, sorry, Ms. McConnelly is just providing me with some updated information. So
Number 11 has a submission.
Raglan Properties is number 11.
Okay, and 19, so Ms. Parham's, and they're not 19 and that is somebody else.
That submission relates to Heritage New Zealand.
Yeah, no, I understand that. Would you say, just from a planning point of view, planning and or legal point of view, that in sort of a natural justice sense, that it would be a bit unfortunate that if the first someone knew that something was scheduled on their property was when they asked for a limb report, you know, when they were about to sell it, and not to just rely on, you know, summaries of submissions in the newspaper, if having looked at the district plan to see what was happening on their property, there was nothing there, and they go, oh, that's okay, and then sort of happily get on with life, only to find out 10 years later that they've got a scheduled tree or a scheduled heritage feature. Would you say that natural justice would sort of dictate that they at least were made aware of that?
From a planner's perspective, yes, I would feel that parties should be contacted, and it is understood that they would try. Yeah,
I'm not trying to point the finger at anybody. I'm just trying to make sure that we're aware of the background.
Yes, and I totally agree. If a landowner is unaware, it is not helpful.
Okay, no, that's fine. Thank you. Is that your view too, Ms. Parham, from a legal point of view?
Yeah, I think it's pretty tough to expect lay people to really follow and understand the first schedule process, particularly when a property is impacted more than, you know, the general public, where there is a proposed building or property to be scheduled in a district plan.
Okay, no, that's fine. Thank you very much. Just one final question, and it's probably again for you, Ms. Parham. The submission from the Ministry of Education is to the effect that scheduled buildings on some of their school sites, which are designated, there should be no scheduling because the designation overrides scheduling anyway, and it would only be appropriate to schedule something if the designation was either uplifted or there was a use on the site that wasn't covered by the designation. Can you advise us on the merits of that point?
Well, that's right, that Section 1762 of the RMA does provide that provisions of the district plan will apply to land that's subject to a designation, but only to the extent that the land is used for the purpose of that designation, in this case for educational purposes. So generally the designation will prevail over any controls in the schedule, but in the event that work was to be undertaken that's outside the purpose of the designation, or the designation is uplifted, then that site is left unprotected if it's not included in the schedule. I'm not aware, I have looked, and I'm not aware of any decision or case law that addresses the issue of whether buildings subject to a designation should be listed in a district plan for heritage protection. However, I am aware that this very issue arose in a 2018 plan change 7 to the Auckland Unitary Plan, and in that plan change the ministry also opposed the scheduling of 3 school buildings that were subject to a designation. That plan change was heard by 3 independent commissioners for Auckland Council, and their decision found that they did not consider the presence of the designation was reason not to schedule the building, even if the consequence of the designation was that the removal or destruction of a heritage building might occur. I note that the scheduling of those 3 buildings has been carried through to the operative Auckland Unitary Plan. So in my view, there is no impediment to the ministries being able to manage the school buildings, which is a strong theme in their submission, if those 3 school buildings are listed in the schedule. However, if you were minded to address their concerns about the confusion that it creates by having it scheduled, but then being able to, or a consequence of the designation is that the buildings might be destroyed or demolished, then I guess an advice note could be included next to the scheduling of the 3 buildings, just advising of the effect of the designation. I'm not sure if that is common practice in other district plans.
No, that's helpful. That's helpful, thanks. Dr. McEwen, presumably there must be school buildings all around the country. I'm particularly thinking of Christchurch and things like, you know, Boys High and some of those sort of character schools, if I could call them that. They must be scheduled in plans all over the place, aren't they? Or is it not common to do that?
No, you're correct, Chair, and not only that, but there are also school buildings that have been carried from the operative plan into the proposed plan that are scheduled. So the Ministry of Education's submission objected to the addition of some new heritage items to the schedule. They did not, as I recall, submit in favour of removing the schools that are already scheduled.
So they're in no different a position from anybody else. It's got to be, the heritage value has to be assessed on its facts. And if it passes the threshold, it should go in. And if there's a specific override because of some other planning provision, e.g. the designation, then I would have thought so be it.
And central government has a policy for the protection of historic heritage for all government ministries. So so that is also a factor, I believe, in the context in addition to the designation.
Okay. So you'd support, you don't find much favour in the Ministry of Education submission saying don't list them. If they meet the criteria, they should be in your view.
In my view, yes.
Yeah, okay, that's helpful. Thank you. Right, I think that's all I wanted to ask. Just give the panel the opportunity, having heard all of that, to see whether they have any questions that they want to ask of staff now before we move on to the submitters. Perhaps
yes,
start with you, Ms. Gibb.
Yes, thank you, Mr. Chair. I just want some clarity, please, around policy 7.1.5 subdivision, where I believe
just bring it up.
Yes, I believe it relates to the Housing New Zealand, the Heritage New Zealand submission. So it may be answered with their submission, but I'm just a bit confused and I'd like some clarity around the change regarding retaining the heritage item or features and their setting within one lot and then removing an identified precinct does not compromise and are sympathetic to the existing historic heritage items or features. I think there's quite a large difference between if you're referring to precinct, that's currently Martingi and Huntly Heritage Precinct. So this change, I'm assuming, means the whole district, any listed heritage item must be retained in one lot, or is it any new or discovered heritage item must be retained in one lot? So I'm a little bit unsure about the meaning, if someone could help me on that.
So the proposed rewording is specifically for the subdivision or development of a site that contains an identified heritage item, and that's why in brackets it says as identified in the Heritage Records Schedule 31 heritage items, because that is what the setting So the heritage record identifies the setting, and that is the area that is protected along with the heritage item, in terms of when you look at any rules and you're wanting to do anything to the heritage item, you also have to consider the setting. So the proposal to ensure that the heritage item and its setting is within one lot is to contain that heritage value. So you've got some sites that possibly are in larger settings, or on larger lots, I should say, but their settings have been identified through Dr. McEwen's work, and that could be a smaller area. What the policy is identifying is that the heritage item and its setting should be in that, that should be what that proposed lot is, so that you don't lose those values. Previously, you've had subdivisions, and we probably have all seen the outcomes of a large villa on a villa on a large site. It's subdivided up, and then you have a large villa on a tiny site, and it loses its setting. Now, the word precinct in this wasn't, it could be read as implying the heritage precincts in the district plan, but my understanding is that that was not what this policy was about. It was about individual heritage items. So the rewording aligns with the other changes proposed throughout the heritage rules.
Right, thank you. That's clearer to me now.
Just following on from that, is there some, like if you look at policy 7.1.4, it says ensure, and this policy says should, which in sort of common English is like a suggestion more so than a requirement. Is there any reason why you've used the word should as opposed to any other descriptor there? I don't think, I don't take should as being as strongly directive as ensure is.
I think it should, I agree. And I think in hindsight, the word should be to retain the heritage item and its setting.
Okay, thank you. And can I just ask, in terms of the setting, I understand that the general point that you're making about the, the villa on a big site becoming a villa on a small site. Are any of the settings, and I must admit, I haven't gone back and measured them all. How big, what's the largest setting that we've got in the proposed plan? Is it in the order of, a large section, or are there areas that are huge?
Oh, well, I will just pass that on to Dr. McEwen, because
just generically, I don't mean down to the last few square meters, but some of these settings presumably are quite large, and how feasible is it in all cases to keep them within a single lot?
And there was a science to her setting.
For example, the Rangiriri Memorial Gate and fencing, the setting encompasses the cemetery. So the setting might be of that extent. Generally, my approach with rural residential properties is that if you have a kind of 5 hectare lot, for example, on which there's a historic heritage house, the setting typically is the immediate curtilage with the garden. It doesn't include the 5 paddocks and the outbuildings necessarily.
Okay.
It's about, and it's trying to give effect to the RMA's reference to surroundings in terms of the definition of historic heritage resources.
Okay. But what would be in general terms of the settings that you've defined in the research that you've done? What's the, is that Rangiriri example the largest or one of the largest settings, or are there areas that, that talk about, like using an Auckland example, the slopes of Mount Eden, for example, which clearly trying to keep everything in one lot there would be practically impossible. I'm just trying to get a sense of what it means.
The largest setting possibly is that for the Matangi Dairy Factory, or the former Matangi Dairy Factory, which would be, what, a couple of acres, possibly? Typically, the standard setting is the land parcel, which in the case of the example Ms. Morris just gave, would be a sort of a quarter or an eighth of an acre upon which a villa is standing. And it's a question of, if a subdivision, what effect that will have, how appropriate it might be to subdivide that property in terms of heritage value. And apologies to everybody, I'm showing my age because I still think in acres. So hopefully somebody can turn that into metrics if they feel.
You're probably not the only one. That's fine. Thank you very much. That's helpful. Mr. Marg, have you got any questions?
No, thank you.
Ms. Tiaho?
Yeah, I just wanted to confirm that you've actually been on a site visit to every one of the properties, or have you just been to a selection?
So I will pass that to Dr. McEwen because she did all the site assessments.
No, I haven't been on the property of every item that's included in Schedule 30.1 or of the schedule as I recommended it. I have viewed all of the properties from the public domain, and I've used a variety of material in terms of historic survey plans, contemporary photographs, information that the council has on file in terms of property files, to assess the building or the structure, and also to establish the setting. And historic aerial photographs and historic survey plans are particularly relevant when it comes to gauging the extent of setting, partly in regard to potential archaeological values of pre-1900 structures, but also because they allow that sense of historic development, which may be relevant to the heritage significance of the item.
Were you able to get to the ones where submitters have made specific submissions on issues saying, look, the facade, or it looks like it's got these values from the outside, but actually there have been significant modern renovations that kind of take away from that historic heritage? Have you been to look at those ones where those issues were specifically raised?
Of the submissions, of the submissions and the further submissions received, I was invited by the Woods to visit their home at Onefero. In taking your query about alterations and modifications, the assessment of heritage significance for Schedule 30.1 is focused upon the exterior of the building. It is entirely to be expected that buildings, whether they're residential, commercial, ecclesiastical, that they will have all had modifications to the interiors over time, because it's, let's face it, we all love indoor plumbing for a start. So modifications that have occurred to the interiors of the buildings aren't germane to a significance assessment for scheduling in a plan whose rules are geared to exterior modifications or the wholesale loss of a heritage item through demolition.
Do you take into account the cost that it might impose on a landowner if their site is registered with this historical value, and the requirement that they now need to upkeep it so that these old buildings can be safe? Is that taken into the balance as to the ranking or whether they're registered as historic sites?
The assessment criteria that are set down in the RPS that the council has to give effect to don't undertake any, make any allowance for costs of maintenance. The assessment criteria don't address seismic issues, the condition of a building. I'm very mindful though that being scheduled on the district plan is a significant matter, and that guides my assessments in order that I can come to a decision that I believe is robust and defensible. And I'm certainly mindful of the fact that scheduling, if an owner wants to be on the schedule, for example, and I'm aware of other jurisdictions that property owners kind of collect scheduled buildings almost, because it helps with their Airbnb kind of promotion. I'm very mindful of the fact that the property ownership might change through the life of the district plan. And I'm very sympathetic to people who object today because they own a property, but I'm also mindful that the district plan may well endure beyond that period of ownership. And so the council has a statutory responsibility to protect historic heritage. And in some cases, the present day owner might like a building to be scheduled, but it's a question of the equity for future owners if the building doesn't have significant heritage value. There are, as well as the impositions, if you will, for heritage scheduling, there are also increasingly available heritage funding, both locally with the council's own Heritage Incentive Fund, but we've seen in the last 5 years or so, government increase money available, particularly for seismic strengthening. And last year, in fact, the Heritage Equip Fund made special funding available for heritage buildings in provincial areas. There's not, at central government level, there's definitely a desire not to have all the heritage protection money just go to Wellington and Auckland. So there are costs involved, but we all bear costs, obviously, for our residential property and commercial property. But there are also incentives available to help owners. And Heritage New Zealand is very proactive in providing that professional conservation advice as well. So it's, you know, there are pros and cons, I believe, to scheduling.
Thank you.
All right, thank you, Dr. McEwen, and thank you, the rest of the council team for what's been a very detailed presentation. And apologies to the submitters, but we really feel obliged to sort of dig beneath the surface to see what the reasoning behind a lot of the recommendations are, and for you to be able to hear those answers as well in the interests of transparency. So we're now due to hear from the submitters. The first one was Mr. Wells, who I don't think's here. There's nobody here representing Mr. Wells, is there? Because if there is, we have read his submission. He's the property owner of 1 Old Topiri Road, which has been addressed in the Section 42A report. But on the assumption that he's not here, I think we'll move forward and now hear from you, Mr. Wood, please, and thanks for your patience.
Thank you, Mr. Chairman. I don't have a lot to add to my written submissions. The building, as I pointed out in my submissions, was for a long period of time derelict. That resulted in the windows effectively being all broken and replaced. The original balconies disappeared. The external doors were all removed. In fact, anything that was capable of being removed was. The building was then renovated in the 1980s. The original roof was not replaced, but it had a dichromatic roof attached to the original slate, and the building was painted, all of which significantly altered its external appearance. While we recognise that, we do, to a limited extent, support the scheduling of the property, but limited to the external concrete front facade, and tower, there is probably little or no public amenity, I would suggest, in the rear part of the property being scheduled. In fact, even the front of the property can not be very readily viewed from the road. We live on a country road, it's 100 kilometres an hour. You can't stop, there's no parking anywhere. So most residents have in fact never seen the property or been to it. In terms of the setting in which the house is located, and I take on board Dr. McEwen's comments earlier in relation to settings. The property until the 1980s was in fact located in a paddock. It's still in a paddock, but there were no gardens around the property. The initial drive to the property was actually straight from the road to the front door. At the moment it runs down a side of pine trees. So the whole setting and aspect of the property has changed considerably over time. The setting that the property is in, really the trees that are there were planted by the previous owners in the 1980s. They have no arboricultural significance or value. There are no formal gardens or anything as such. I think what I would say is that if council are minded to schedule the property, that perhaps we would agree with Heritage New Zealand's suggestion that we have an external architect assess the architectural qualities. I'm not an architect, of course, so I can't particularly comment on those. It is unusual in that it has a tower, but as I say, within the wider community, the house is not particularly well known. It's not visited. You can't particularly see it from the road, certainly not easily. And I think it appears the house's main claim to fame is that it appears as a small black and white photograph in a prominent book on architecture. I think that's probably all I wish to say.
All right, thanks, Mr. Wood. That's pretty clear. Can I just ask, you signed the submission as a trustee of the owners. Are you a professional trustee, or is this your family home held in trust?
It's my family home held in trust.
Thank you. Let's just see if there's any questions from the rest of the panel. Ms. Tiaho?
No, I was very clear on what you were seeking. Thank you.
Mr. Marg?
As was I. Kia ora.
Ms. Gibb?
No questions, thank you.
No, and I think there's obviously a contest of facts here. If we were, and I think we probably would, at some point in our deliberations process, appreciate the opportunity to at least see the property, would that be something that the staff could arrange for us to do?
We would be more than happy, yes.
That's fine. Just on that, for those of you that are listening, this district plan hearings process has still got another 12 months or so to run, something of that order, and we're not issuing any decisions until we've got the full package of everything in front of us. And you can see that from today in terms of, there's rules from residential chapters and things that are contained throughout the plan, and we're not minded to make sort of piecemeal decisions that might have consequences for something that we're yet to hear. So if we were to do that site visit, don't be concerned if you don't hear from us for a period of time, because we'll do that in the context of the district as a whole, rather than making a special trip just to see one property following the hearing. So we'll be in touch in due course, but if you don't hear from us immediately, don't think that we've lost interest, because we haven't.
No, thank you.
All right, thank you very much, Mr. Wood. That's very clear and very helpful. Thank you. Which brings us to the Remu to Remove Buildings Limited, which is the Kassouf family, and I hope I pronounced that name right. I've already made one error in identifying the family. I'd prefer to avoid making another one. Is that close enough?
Hi, Phil.
You might need to, one of you needs to turn, maybe turn. Are you in the same building, or are you in different buildings?
We're in the same building this morning, yes.
That's what I thought, because I could see some windows, LED light windows in the background, and when we heard the reverberation. So if we can just have one computer sound system on at once, that would be helpful.
Oh, we have gone to another room, so
oh, great.
It should be good.
That's great. All right. Right, we're in your hands.
Thank you, Mr. Chairman. Hello, Commissioners. We are Alan and Bronwyn Kassouf, and on the other screen is Clive and Pauline Kassouf. We're both brothers and sister-in-laws. We are owners of Remove House. We are here in support of our further submission and are willing to answer any questions you may have. You have a copy of our further submission, so we'll take that as being read.
Thank you.
In summary, we have a binding agreement with Council completed in 2004 for the property at 40 Main Street, Remove House, not to be listed on the Council's heritage schedules. This came about when the Council approached us in 2003 and 2004 to have our two properties, one at 40 Main Street and one at 116 Main Street, listed in the heritage schedule of the district plan. We opposed both these properties going onto the schedule. Council approached us for a meeting which was convened in 2004 and chaired by Mr. Pritchard and attended to by myself and Clive in person with 3 other Waikato DC staff at Remove House itself. A short time after this, we were contacted by Council and were asked would we consider having one building on the heritage schedule. The reason behind that was during the discussion which took place in the meeting, we emphasised the fact that having both buildings put in was a financial burden on one family, a significant financial burden. We didn't propose that one go in. We were opposed to both going in, mainly because we had plans for both buildings, which we did not want to be impeded. So the Council made this approach to us of having one building put on the heritage schedule. We went away and discussed it as a family and came back and thought, well, there has to be a compromise between us and Council. And so we felt that, yes, we would entertain the suggestion by Council, and they gave us the process of electing one building. We elected to put the building in 116 Main Street onto the schedule with the agreement in place that 40 Main Street, Remove House, be left out of the schedule and left out of any future scheduling processes. And that was the agreement we entered into in good faith. Council at that time told us they would document the meeting, document the file, so that we wouldn't have to go through the process again. Because of this, we did not oppose the scheduling of 116 Main Street, and that went through unopposed and has got heritage status. The long interview between 2004 now shows that the agreement was in place. It was witnessed by us both being present at the meeting, both myself and Clive. We attended the meeting and we had the discussions in person. With no disrespect to the sitting panel, we don't believe we should be here because we have a binding agreement with Council that there should not be a conveyed heritage on the building by the consultants. To reject our submission is to overturn the binding agreement we have with Council. Just further on that, I would just like to add that as a family, we are really confused by the process this time round. In 2004, it was more consultative. We were approached directly by Council saying that, look, we're thinking of putting these two properties in. We understand the implications for you people as owners. Would you like to talk about it? And of course, naturally, we took the opportunity to discuss it in person, up front, and so that all views could be canvassed. their views, our views, what it meant for the future. And we felt that process was more conducive to getting an agreement. This time round, we're totally confused. Every time we write to council, we get a different answer from a different person. There's a different report. The reports are written by different people. There's consultants involved. We're just not too sure exactly who we're dealing with. Also, we're a little bit confused by the fact that the heritage designation on this building, because we've never ever been approached by anybody asking about the history of the building. There is no, as far as we are aware, there's no documentary or written record of the building, why it was built, how it was built, who it was designed by, why it was designed the way it is. And so our take on that total process is the fact that the heritage significance is to the Kassouf family and it's not to the community at large. We'd like to point out the fact that this property has been in our ownership for 3 generations. It has never left our ownership and we don't really intend for it to leave our ownership. It's important to us as a family, but having said that, you know, we are progressive, we wish to move on, and each generation has used the property for a different purpose. And we don't see that as being allowed to take place if it is scheduled. I think that's about the summary of our submission. Thank you, Mr. Chairman.
Thank you, Mr. Kassouf. That's clear. Can I just ask, just to, you've mentioned the property by name and by street address. Is that located a little bit north of the Bottle-O on the same side of the road? Is it? I mean, it's got the curvy bits and a bay window on the left-hand side. Am I thinking of the right property? Is that the one?
You're exactly right, Phil. Yes. That's
okay. Thank you. I just wanted to be clear. And the binding agreement that you talk about is a verbal agreement. Is that right? You haven't got that documented by way of a like a formal signed agreement that you've entered into with the council. It's on the basis of the meeting you had with Nath Pritchard and others. Is that right?
That's correct, Mr. Chairman. The fact was that they indicated to us that the meeting would be minuted, and also the fact that our property file would be noted as the agreement, and we just took that as being enough.
And they didn't, for whatever reason, didn't follow through.
No.
Okay. All right. Well, that's the position's clear enough. We'll just have to obviously grapple with that. Let's just see if there's any questions from the panel. Ms. Gibb?
Yes, just for clarity, thank you, Alan. Is this the current building that's being used by Dr. Gates?
Janet, no, we're next door. It's actually currently used by the family as a business premise for an accountancy practice. So we're next door to Dr. Gates.
I got confused over this cul-de-sac past Bottle-O because you don't get to it in that cul-de-sac, do you? So
no.
Accountancy. Okay.
Yeah.
Thank you for the clarity. Thank you.
Thank you, Janet.
Mr. Yahoo?
So, what are your plans for the future of the house, the Remu house, that you don't want scheduled?
Thank you, Linda. Our plans at the present point in time are stalled a little bit by the fact that Huntley has just been bypassed by the new motorway, and so effectively we're waiting for the consequences of that and a little bit unsure how the town will develop. But as a family, what we are probably intending to do at this point in time is that the building will be removed at some stage in the foreseeable future, and 2 townhouses will be built facing the river for our retirement. They'll be purposely designed for older people because we believe that merits the site. We're probably going to occupy them ourselves in our retirement, but if that doesn't take place, then they'll be rented. But that's our current view. I can't say definitively that would be what's going to take place, but I've got to be honest with you, that's what we are thinking at the moment.
And so if you remove it, what would you do with that's the brick looking building, yeah.
That one there is there.
Yeah,
Yes, that's correct.
brownie one. So what would you do with it to remove it? Is it relocatable, or would you have to dismantle it in order to remove it? Is it just, you just demolish it, or?
Yeah, that's quite right, Linda. It is actually, the construction of the building is actually a permanent concrete floor. And the buildings and the archways are all stressed back to that concrete floor. So yeah, there's no, I've got to be honest with you, there's no way that it actually could be relocated.
Right. Okay, thank you.
Thank you. Mr. Mark?
Nothing from me, but thank you for your presentation.
Yeah. Can I just add one further thing, Phil?
Yeah, please do.
Yeah, I don't mean to belabor the point, but the fact is that we really struggle with the consultation process and the feedback, and we sort of struggle with where we're at. The historical significance of the building, we struggle from the point of view that we've never been asked as a family why it is the way it is. We've never had an approach from council or anybody saying, come through the door and come and say, well, look, we're thinking of scheduling you, but what's the history of the place? Because the way it looks is not its history. The building was built by our grandparent. The design is is for a medical purpose, and it's nothing to do with an architectural building or a building of its time or anything like that. The actual design is based on a medical ailment our grandfather had. They had come from Australia, and he had a home in Australia that was similar to this, and effectively the materials used were not of a normal construction of that period, but because he was a stonemason. So really the history of the building belongs to the Kissouf family, and we feel a little bit strange that it's part of, it's designated as a design of the time.
All right, thanks, Mr. Kissouf. Do any of the other family members want to say anything? Better give them the opportunity, seeing as I've previously upset half of them. And you need to turn the sound on, Mr. Kissouf, if you want to say something.
Here we go. Sorry. Yeah, we're the young ones. No, I think Alan has covered it fully. You can't get much more of that. I'm a great agreeer that a binding agreement is a binding agreement. And I was there at the meeting, and I got the phone call, and it was done. It was supposed to be noted. I understand there's a bit of a story going around that there was we were told there was a flood and some records were destroyed around that time. I'm not sure if that's true or not, but that's what we were told. And that was some time ago. Thank you.
Okay, thanks very much, folks. That's very clear. And as we said to Mr. Woods, we've got a long process in front of us. So this is probably a property that we won't need to physically go and look at again, because we'll probably drive past it a number of times, notwithstanding the new motorway. So we're familiar with where it is, and I think we're pretty familiar with the issues. We'll just have to sort of grapple with the evidence we've heard from everybody today, and we'll do that in due course. So thank you very much. And I should have said to Mr. Wood, and same to you, you're welcome to stay. You're also welcome to go and do something in your accountancy business if you'd prefer to do that. But entirely over to you. But thank you for your submission.
Thank you.
Thank you.
Thank you. Thank you, committee. Thank you, Phil.
Thank you very much.
Appreciate it.
Which brings us to Heritage New Zealand, please.
Can you hear me now?
Yes, we certainly can. Thank you.
Thank you. Can I ask, I did send through to Fletcher late yesterday a response statement to the council's rebuttal.
Yes, we do have that, and I can put it on the screen if you like.
Okay, So what I'd like to do today, I'm Carolyn McCallie, I'm the planner for the Lower Northern Office of Heritage New Zealand, and Robin Byron is with me, she's our conservation architect. And we've written a response to the Council's Section 42A report, so today I'm just...
Oh, that's not it, sorry, I put the wrong thing on the screen. Sorry, I was talking to myself, didn't mean to interrupt, just realised I put the wrong, that's your submission.
And today I'd just like to respond to the outstanding matters that are in the rebuttal, the Council's rebuttal.
Yes, that's helpful, thank you.
Yeah, so with regard the earthquake and fire safety policy and rules that Heritage New Zealand sought, just like to talk to those a little bit further as they've been rejected by the reporting planner. As you're aware, many building owners will have to undertake earthquake strengthening and fire safety works, and these works are beneficial for the long-term conservation of the building, and improving seismic and fire rating has obvious benefits for neighbouring properties as well, particularly in an urban town centre situation. And we think that a policy should recognise that encouragement and support needs to be given to these owners. In terms of the encouragement and support I'm envisaging through this, we're looking at staff advising people of the possibility, subject to conservation and engineering advice and compliance requirements, that earthquake strengthening works could be undertaken in a staged manner. This will help with people's budgeting. And also advising of possible funding streams to obtain conservation and engineering reports, as well as any government guidelines or advice. And Dr. McEwen's referred to a number of those in her earlier statements. Other actions that Council could undertake would include developing guidance for those who have to undertake these works, and there are examples from other councils that could be followed, so you're not having to invent something new, and also providing to owners subject to owner agreement contact details from those people who have had to undertake similar types of work, just so they can share their knowledge and network. And certainly in the wording of the policy, it wasn't the intention that heritage wouldn't be given regard as part of these works, by including in the policy that significant loss of associated heritage values is minimised. So I've just included the two policies there, they were direct from the submission. I have noted that the reporting planner does consider that these matters can be considered under the existing rule of additions and alterations. So if Heritage New Zealand's request can't be accommodated for a separate rule, I would further suggest that a matter of discretion could be included into the additions and alterations rule. And I've just outlined an example there. The chosen methodology of any earthquake strengthening, safety or fire safety works minimises the effects on heritage values as far as practicable. Robin, Ms. Byron, our conservation architect, will talk after me to including the bowling green as part of the War Memorial Bowling Club. And just with regard to the Ministry of Education statement that's been talked about, I certainly agree with Dr. McEwen that the Ministry of Culture and Heritage and the Education Department both have policies and guidelines relating to actively encouraging the district plan scheduling of buildings, even though there is a designation. And I'd just like to pick up on a comment made in that statement where the writer has advised that they think that the Heritage New Zealand listing provides the necessary protection and recognition. I just need to clarify that a Heritage New Zealand listing provides recognition, but it doesn't provide protection. We do rely on district plan rules to provide protection for those buildings. In conclusion, I would like to say that Heritage New Zealand are very pleased that so many of our submission points have been recommended for approval, and we do hope they are carried forward into the decision-making process. And we consider that this will result in improved outcomes for the historic heritage items scheduled within this district. I would now pass over to Ms. Byron to comment on the bowling club.
Thanks, Ms. McKellar. Do you want me to go back to your summary statement? Can you see that on the screen?
Yes, I can.
So it's the Otawa War Memorial Bowling Club, this one here? Okay.
Yes.
Where's Ms. Byron gone?
I'm here.
Oh, there you go.
Mr. Chair, Commissioners, if I am able to share my screen, I can put an image of the Otawa Bowling Green up on the screen, if that's helpful.
No, that would be helpful. Let me just get rid of mine. Just got to, and then I'm sure Mr. Bell can accommodate that. I've just got to find where, there we go, stop share. You might have already stopped me, have you? No, here we go. Give me 2 seconds.
No worries. Okay, and I will share screen. And
you've got it.
There we go. It's just coming through now.
I think the image will come up now. There we go. So
I just wonder if you wouldn't mind, just if you can, just make that just a little bit bigger. It's we can see it, but it's not super big.
This should do it. I don't know why. It just takes a couple of seconds to load, perhaps.
Might be a heritage computer. Might be a heritage computer.
That's very possible. So I just wanted to address the Otawa Bowling Green. The Otawa War Memorial Bowling Green. It's located across from the local public hall. I don't know why this keeps moving. And it was formally opened in November 1954. It has historical and social significance for the way it reflects local commemoration of the 2 world wars and central government initiatives at the time to create practical memorials to the wars and also encourage recreation. There's a stucco wall and archway along the road frontage through which access is gained to the bowling green, which is flanked by associated structures and including a flagpole. The granite plaque, which you can see in the center above the arch, is inscribed with the words, quote, "In loving memory of the men of the district who fell in 2 world wars, 1914 to 18, 1939 to 45. It's been recommended that the wall and archway be scheduled, but not the bowling green and associated structures. Heritage New Zealand has advocated for the whole of the bowling green to be recognized in its scheduling, which I agree. I believe New Zealand war memorials in the form of bowling greens are relatively rare. The Heritage New Zealand does have a listing for a war memorial bowling green located in Oamaru in the South Island, which is a component of a complex that also comprises Return Service Association club rooms and a memorial garden. At Otawa, there's a standalone memorial, so it's a bowling green on its own across the road from the hall, but on its own, the integrity of which could be maintained if the green itself were included in the scheduling. The wall and archway refer to and have a direct relationship with the area of landscape defined by the boundaries of the bowling green. While the structures which rim the green are of interest, as the provision of a pavilion was not made originally and only constructed nearly a decade later, I do not think they are as critical to scheduling recognition as the Bowling Green surface itself. As stated in my evidence, without the inclusion of the green, the retention of only the gates and the wall, kind of two-dimensional retention of just that road frontage, I think risks their meaning being compromised, being diminished, and misrepresented in the future if the landscape and spatial area of the green is not maintained through scheduling, vulnerable as it may be become to filling in by later development. And also, I just note that the flagpole, which was an original and significant feature of the Memorial Bowling Green, should also be included, should be noted for inclusion. It's situated along the frontage just to the right of the arch, as you can see. So it sits very much as part of that wall and gate composition. And that's basically what I have to say. I'm prepared to answer any questions on this or other items. Thank you.
Thanks, Ms. Byron. We might unshare the screen so that we can see the faces a bit more clearly, if that's okay with you. I think we've
that's good.
Probably got a clear picture of that. So, Mr. Bell can unshare you, or you can unshare yourself. Be helpful. There we go. That's good. All right. Let's see if there's any questions. Let's start with you, Ms. Gibb, please.
Yes, through the chair. So I do have a question of Ms. Byron. How would you see this compares with a previous discussion about surroundings of heritage items or buildings? We've had a bit of discussion. I'm not sure if you were already in the meeting when we talked of
yes, I was.
The building in relation to surroundings, and you've just brought that up in the landscape and spatial area around the wall and the archway. Do you want to elaborate on that? Do you see it as the same, or is it different to what we were talking about before?
No, I think that for any heritage item, there's always some consideration of where that item has originally been placed in a landscape. There are often associated trees and gardens with it, and it is really important to. And I think you have to look at it on a case-by-case basis. But I think that there's almost always some sort of curtilage or some sort of setting associated with a place that has meaning to it. I mean, I think in this case of the bowling green, it only makes sense as a memorial bowling green if you include the green. You know, if in worst case scenario, if you allowed development to occur over the green and all you had left was the archway and the wall, then you would lose the kind of sense of it being a memorial place of recreation. All you would have left is the entry, which would be significant, but you would lose a lot of the meaning and significance if you lost that area of landscape associated with the green, in my view.
So at some point I would like to hear the rationale from the expert witness, but I'm not sure, Mr. Chair, when you would want to do that.
From the council?
Yes.
Because, well, I'm happy to get a response from Dr. McEwen now, if that helps you.
Thank you.
The heritage item record form that I've prepared for the Ottawa Memorial Bowling Club gates and boundary wall, which is what has been recommended for scheduling, includes as its setting the gates and the boundary wall, the bowling green, its pavilion and auxiliary buildings, but not the full land extent, because there are actually 2 land parcels on which the bowling club, former bowling club, is located. And you probably can't see, but at the bottom of my report,
let me see if I can let me pull that up. I've got that on file here. Then we can share the screen, so that way we can.
So
I'll just take me a minute to find it if that's helpful.
Currently, the former bowling club, which closed in 2013, the club was dissolved, in 2013. Currently, it sits on 2 land parcels, and one is a kind of an L shape that tucks around the larger parcel. So I've recommended a portion of that, which covers the bowling green and those auxiliary buildings. That would also encompass the flagpole that Ms. Byron has just talked about. And obviously, we've already had some discussion today about the way that the district plan addresses the surroundings for a scheduled heritage item, which I have recommended as the gates and the boundary wall. So, thank you.
Is that the one you're looking for?
Yes, thank you very much, Chair. So, to the left, between the road and that turquoise line, that is what I've proposed as the setting. So any development, subdivision and development that would be occurring upon that site, now that the club is defunct, would have to take into consideration the impact on the heritage values of the site. So that's where the setting, I think that we, Ms. Byron and I are not, we're in disagreement, I believe, in terms of the status of the bowling green. We're not in dispute about its relationship with the gates and the wall, but I believe that the setting encompassing the bowling green and the auxiliary buildings and the flagpole is the appropriate way to go in this instant.
Thank you. Does that help, Ms. Gibb?
Thank you.
Ms. Tiaho?
I also had a question about the bowling green. I didn't know that the club was defunct, but if somebody wanted to put a park in there or gardens rather than maintain a bowling green that's not used, that would be sympathetic to the historic value, wouldn't it? So it's not. I guess the point I'm making is it's not necessarily the retaining of the bowling green as a bowling green, just as a setting that's suitable to accompany the wall and that arch. Is that right?
Yes, I think that it could be, if it's used for some other, as a park or some other sporting activity, I think that would be perfectly acceptable. I think that it would start to diminish the values if it were planted with trees and flowers and so on, then you'd lose the sense of it as a kind of open landscape area. But if I seem to have misunderstood that what was being proposed for scheduling was just the wall and gateway, because for some reason my impression was that it didn't include the bowling green, and I'm very happy if it does. So that's
Well, I was going to ask that same question, because I'm not sure that it necessarily says that, does it?
No, Chair. The setting is the contextual. So under the schedule, what's recommended is that the gates and the wall are protected. But as we've talked about previously, the same as a house, for instance, on a site, there is the setting. And so when you look to do anything to the scheduled item, you have to understand it is that the effects of whatever you're proposing to do to that scheduled item, the context of the setting is to be considered as well. So that does not mean that the bowling green per se is protected. It's just that it's recognised within the setting of the gates.
Where does it say that in the, I mean, presumably, I mean, where does it say that? Because there's a blue line or a turquoise line on the plan.
Yes,
but there's nothing that I've seen in what's written there that says the setting associated with the gates and the boundary wall are in the part to the west of the turquoise line. And should they say that?
If you go to the bottom of the first page of the report,
yes,
Chair, there is a surroundings, contribution to context and extent of setting. And
yes.
So the item that I have recommended for scheduling is the
I see. Okay.
wall, but with every item that has been recommended for inclusion in Schedule 30.1, we have identified by words and by the aerial the setting, because that bears upon how the council can protect historic heritage from inappropriate subdivision use and development. If I can suggest, Mr. Chair, I think we, on behalf of the council, I think it might be useful if we clarify the underlying zoning of this property, because a recreational future use, now that the bowling club has been dissolved, a recreational use of the green, as one of the commissioners has already suggested, would be in keeping with the heritage values of that place. And so I think perhaps that's a little piece of information that we could provide in order to clarify the particular case that we're dealing with here.
Mr. Chair, could I make another comment on that with regard to the extent of the scheduling?
Yes.
I think that I personally think that the green ought to be part of the scheduled item itself, because the wall, the gate, the flagpole, the green are all integral features. The green makes the wall and the fence make no sense without the green. It's an integral part of that scheduled item. I think it is, going back to the first question, I think it is a little bit different than having the site surrounds of a scheduled house, for example, where you might include some trees and gardens. In a way, they support the setting supports the heritage item, but it's the most, the values are really often embedded in the structure itself. And
I think there might be some, sorry to interrupt you, but there might be, I think there's some sort of inconsistencies in the way, and I mean no criticism of it, because if you look at the last sentence that's on the screen there, it says the extent of scheduling includes the gates and boundary wall, the bowling green, its pavilions and auxiliary buildings, rather than the two land parcels. So that, I think, makes it clear that the scheduling includes the setting as well, but it's not quite what the rest of this talks about, if you know what I mean, because I'm just trying to find where it, sorry to be screaming around all over the place. It says the features are the gates and the walls, and I just wonder whether there is a slight confusion by the way that the description and the scheduling are worded, or are you folk happy that it's captured okay?
Well, it would be better in that physical description and significant features to include the bowling green itself, I think.
I take your point, Mr. Chair, about that confusion, and I believe that in order to better represent my intention, it should say the extent of setting rather than extent of scheduling.
Okay, I think that would be, Is that a global issue that relates to all? I must say I haven't looked at the individual reports from that point of view. Is that a global issue, or is that just arising in relation to this particular one?
We think it's there is the potential for it to be more of a global issue, and
Okay.
it's something that we need to just have a look at.
Okay, that would be helpful. I don't think there's any point in trying to, redesign things by committee here, but I think the point has been well made, and I think we understand things, so that's very helpful. And I've forgotten where I've got to in asking the panel as to who's who. I think, Ms. Tiaho, you've had the questions that you want to ask, I believe, and so has Ms. Gibbs, so that leads you,
Yeah,
Mr. Mark.
Just one question in relationship, and remind me if it's on, if I've missed it, but with the club being defunct, who's legally responsible for that land? The two parcels that
We don't know.
We don't know.
Council, because we own the property.
So Ms. McConnelly has just advised that most probably council, because council.
Right. Thank you.
I was going to ask who owns the land, but that's been answered. But would something like a community vegetable garden, for example, would that constitute a compatible activity with the scheduling and with the nature of that setting, for example?
If I can offer a comment on that, Mr. Chair, I think one practical difficulty I would see in that, I believe, yes, a community use for that property would be entirely consistent with the community value that the memorial gates and wall now have. From a practical point of view, I'm not sure how you would apply for a resource consent to dig up the grass of the bowling green if it was explicitly scheduled in Schedule 30.1 in order to plant it. And I really hope that doesn't sound kind of at all facetious, because that's not my intent at all. But practically speaking, my professional expertise is in assessing built heritage and the associated sites of that heritage. This is not an archaeological site, as far as I'm aware, under the Heritage New Zealand Pohere Act. So I'm just not sure how practically you would deal with the grass, but the zoning, if it is recreational zoning and it is the setting of a scheduled heritage item, I believe that would be sufficient.
Okay. All right.
Mr. Chair, can we, Ms. McConnelly would just like to add a piece if that's possible.
Thank you, Ms. Connolly.
I need to do some further work on this, Mr. Chair, just to actually check out the zoning, and also I need to see whether it has, if it's zoned under the Local Purposes Reserve Act or anything. If so, that will actually dictate what can actually happen on that property. So can we come back and just, do some further work and come back and bring this back to you?
I think that'd be helpful. I think we're sort of, just from the nature of this conversation, there's probably more to the question than simply in relation to this one item where there's a conversation about what's in and what's out. I mean, if there are, and it was really the point of the questions I was asking earlier this morning, if there are unintended consequences that mean good outcomes are precluded because of the very inflexible way either policies or rules are written, I think we'd be pretty keen to make sure that as much as possible that is ironed out, because it would seem to be a shame that someone would point to a policy or a rule that says, actually, we think this is a really good idea, but the way we've drafted things mean we can't. So sorry, it's, go and do a plan change to, turn a sod over to plant some kumara or something. That would seem to me to be a really unhelpful outcome.
Agreed.
So I'm not sure where we go with it, but maybe we wait until the end of the hearing today, and we might just ask the staff, the council staff, who we always give the right of reply given what they've heard during the day, to perhaps think about where we might go to from here on this issue?
Yes, thank you, Mr. Chair.
Which is probably a bit of a hospital pass, but we're allowed to do that. Mr. Marg, did you have any further questions?
No, you followed up my question on the other purposes of what the land could be used for, so I'm happy to take it.
Ms. McKelly, I asked quite a number of questions earlier on of Ms. Morris about the drafting of various objectives and policies, and I don't think it's necessarily effective or efficient to go through them again, because we might be here for an extended period of time, which is probably not helpful. But what I want to just ask you in philosophical terms, or in big picture terms, is how do we avoid a situation where something's clearly got significant heritage value, but in its current form, it's derelict with no obvious sort of pathway out of derelictness, if I could put it that way? Do you think it's important to do two things? One is be very enabling in a policy sense of adaptive reuse, which is sort of mentioned in the objectives and policies, but sort of in passing. It's not really seen as being up there as front and center. You know, it's more about the protection of historic heritage. And I mean no criticism in expressing it that way. But it seems to me, at least, that adaptive reuse is fundamentally important if a lot of these buildings aren't to fall into disrepair, especially using the example that we've just talked about. I imagine that in a post-COVID world, the council's budget for the maintenance of, you know, gates of a disused bowling club and the buildings around it would not be near the top of their list. You know, they'd be well down the batting order. And I could envisage coming back in 15 years' time doing the district plan hearings again, probably won't be me, of saying, you know, these things are really in a very sorry state of affairs, to the point that they don't retain much of their original value because they've been unloved for so long. So that's the first part of the question. And the second part of the question is, there seems to be, in the way that the policies and policies in particular have been reworded to put a very strong emphasis on protection. And in a few places where there has previously been mention of protection while ensuring, you know, that things are safe, for example. Do you think it's appropriate that there be at least a mechanism to be able to say, even for a non-complying activity for a rank A building, that if it's inherently unsafe and no practicable way of actually fixing it, that there should be at least a pathway to remedy that situation, even if it involves demolition? So there's two parts to the question. That's by way of background. The question is, should there be a stronger emphasis on the benefits associated with adaptive reuse? And secondly, should the policy framework be so rigid in relation to protection that if something that was inherently unsafe, there's possibly no pathway for demolition to ever be considered under the district plan framework because of non-complying status, because you'd be contrary to the objectives and policies, saying that it had to be protected, and the effects almost by definition would not be no more than minor?
Well, probably ask Ms. Byron to help me answer this. Certainly with regard to a building being unsafe, and that's the context of possible demolition, Heritage New Zealand would think that it is important to give safety issues due regard. But I think that's something that would come out in the wash as the consent was processed. I don't see the current group of policies curtailing that element in decision making. With regard
so leaving aside wording, you would, I'm not suggesting for 1 minute that, you know, that there's a get out of jail free card to say run the bulldozer through all the heritage because no one can be bothered fixing it. So there's a pathway, so use it. We're not suggesting that at all. But you are agreeing with the general proposition that if something was inherently unsafe, and it couldn't be made safe in any practicable sense, there was at least a pathway to enable a consent to be granted for demolition, leaving aside how that might be worded. You agree with that as a proposition?
I think obviously you'd be looking at engineering reports and all of those sorts of things. You'd have exhausted your conservation advice on that matter. Robin may have come across situations like that and may want to add some comments, Robin.
Yes, I can do that. I think just in terms of, I think one has to be careful in suggesting that protection prohibits change in buildings. In the long life of buildings, you know, even if a building retains its original purpose, it does adapt. It adapts to different types of uses. It adapts to needing to be modernized. It adapts to different evolving changes and needs. And so I think that, you know, while the scheduling implies and the rules imply protection, there's also in conservation, the wider definition of conservation includes adaptive reuse. That is one of the mechanisms by which buildings are conserved. They're adaptively reused. They're restored, they're reconstructed, they're adaptively reused.
I think that's really helpful. I suppose we're looking at the fact that people that are entitled to read the district plan and rely on it probably aren't as knowledgeable about what those terms mean and what's envisaged. So we're very keen to try and make the plan as plain English as possible so that you know, the man or woman in the street can read it without having to go and hire someone to say, what does this mean? So I think the explanation that you've given is very helpful.
There might be some statements in there that just clarify what protection involves and the recognition that buildings evolve and change, and sometimes that evolution and change actually contributes to its significance over and above its original values. Yeah. Okay,
well, that's very helpful. Thank you for answering those questions. That's
on the subject of demolition, I think that it's, you know, I think one has to, again, thinking of if a place has been identified as significance, it has a significance to not only, it has a wide significance to the community, and you have to explore all options. You know, it is remarkable to me to see some places that become disused and are run down be regenerated. It happens, you know, it does happen. Suddenly someone comes along, sees the potential and is willing to put in the investment. And I think you have to be very cautious about you know, setting a too low a bar to enable that to happen.
I don't think we're suggesting that the bar should be low. I think we're simply saying that if the circumstances warrant it, and all the sorts of things that you've talked about still remain such that it's actually impossible to save something, and it's going to fall down, you know, the next time the wind blows, and I'm being facetious to make the point, and someone's likely to be walking past it and be killed, then if you get to that point, you at least want to have a mechanism to say the district plan can contemplate a pathway for that to happen, as opposed to saying, well, the way we drafted the plan says, even though it's, you know, blindingly obvious that that should be the outcome, there's no way through the district plan that says that's what we should do. And I think that's all we're trying to tease out. And I think the conversation we've had is very helpful, and your approach to it's helpful as well. So thank you for that. Are there any more questions from the panel? All right, well, thank you both very much for what's been very clear and for the very detailed and helpful nature of the submissions that you've made. So thank you very much. And as per the others, you're obviously welcome to stay, also welcome to go and do something that might be a little bit more productive than sitting and listening to us talk. But thank you again.
Thank you.
Welcome. Thank you.
That brings us to Ms. Kelly, Ms. Madsen and Ms. Miller. We're in your hands, ladies, as to how you would like to make your presentation to us. The way that it's been, I mean, I know that you've all made individual submissions, which we've read, but you're grouped together in terms of our agenda. But we're in your hands as to what the way that you'd prefer to present to us. All I would say is that we're keen to get to the nitty-gritty of what it is you're seeking and why, as opposed to traversing the history, because we have read the history and I think we're pretty well aware of that. So we're in your hands, and over to you.
Good afternoon. I'm Jenny Kelly. I'm going to present my submission number 621st, and Kathy Miller and Christine Madsen will follow, and I will present my other submission 590 at the end. Submission 620 was made 2 years ago, and this submission is on behalf of the Waikato District Heritage Forum. Those present would like for the concept of the heritage character around the Rangariri Hotel and Village, Rangariri Road and Talbot Street to be retained. Waikato District Council's proposed district plan claims in Chapter 7, Historic Heritage 7.1.1a, to be a district that acknowledges its past by recognising, identifying, protecting and promoting heritage. Our reasons for making the submission are that Rangariri is definitely a significant part of Waikato District's and New Zealand's heritage, with growing tourism opportunities. One professional interpretation seemingly specific to architecture or opinion should not be sufficient for council to abandon the fostering of a heritage concept to both enhance Rangariri and its visitor experiences. Rangariri's significant small and confined village provides a perfect opportunity for the council to demonstrate its claims to acknowledge its past by recognising, identifying, protecting and promoting heritage. Just a little aside, I have been aware, some of my earliest memories are in Rangariri because my parents shopped at the two groceries that were then existing. And in 2015, I wrote a book, Rangariri, Lives and Times, 1870 to 1970, to capture the essence of the post-tragic war in 1863. A heritage identifier of some kind, to my mind, is vital for Rangariri. Kathy, I hold.
Yes, that's really the essence from all of us. It's very simple. There's not a lot of complicated information needed about this. Rangariri is probably the most historic town in New Zealand. It gets absolutely no respect at the moment from council. We feel that Dr. McEwen's speciality is in buildings. What we're really urgently requesting is some sort of protection and cultural protection for the town. And the Minister, the Education New Zealand, the Ministry of Education's just made Rangariri a place to visit for high school students. It's now part of the history curriculum in high schools. We have 40 people on a bus coming from schools from around the district and Auckland. We've organised, locally, we've organised historic tours for them. We have a museum, we have the British Army Cemetery and the memorial gates. Beside the cemetery is a residential zoned property with no protection for a setting against the cemetery, for instance. We have the NZTA, the New Zealand government, Tainui, have got together, and I was privileged enough to go to the closing of a road where everybody agreed that this town has reverence, it should be acknowledged as part of New Zealand's history, and yet we seem to have absolutely no protection, respect, or design guides or rules as to how this town should progress forward. There aren't many people in our small district that don't understand the reverence of the history and the fact that it needs to be retained. And if we're going to teach our children the history of the Battle of Rangiriri, we need to be able to encompass the whole village into an historic atmosphere. At the moment on the boards, there in the pipeline, there are multi-million-dollar opportunities with people actually making very large plans for tourism opportunities. We feel that we need a blanket over the whole town. It doesn't matter whether there's going to be a rezone to commercial zoning in the middle of town, but over as an umbrella of that, we need some sort of historical and cultural protection that blends in with what's existing there. That's pretty much it. Thank you.
Right, thanks, Ms. Miller.
Yes, Christine Madsen. As a lay person, I support both the Waikato Heritage Forum, Ms. Kelly and Ms. Miller. And I believe, after listening to all the introductions this morning, that there's no part of the plan that really addresses Rangiriri residents and ratepayers' wish to have a special heritage area that encompasses the whole village and the battle site of Rangiriri. This area is all part of the Rangiriri setting, and it should be protected along with the heritage items within it. Around the Pa, Te Whero's Redoubt, and the historic British and Maori cemetery, which was the site of a significant little Maori church. And likewise, the historic hotel from the early 1900s and the housing within the village. I believe we have a real potential here to make a place with a difference. This is a very significant area, and it needs to have some sort of a special zone, whether it's whatever it's called, but it needs to have some special zoning to protect it, so that when visitors arrive in the area, they are greeted by the wonderful symbolic Pa and the old Pa workings, but when they drive on down into the village, they're greeted with something different, something that is part of the history of New Zealand, because the school curriculum is covering this area, and from our visitors book it shows that we have many schools visiting, and apart from the schools there's also local visitors. In fact, I was there last week and I had 2 visitors who were following the Waikato War map, but they were actually using the app on their phone and listening to all the messages as they travelled down the Great South Road and into Rangariri. And they were looking for somewhere to eat and somewhere to rest before they moved on down to Te Awamutu. And I'm sure when our borders are open again, we're going to have many visitors from overseas as well. In September 2018, a group of the 94th British Regiment came through Rangariri. They were following the routes of their Mercer's battery. They are a British regiment. They fight under the New Zealand flag. They have a Kiwi as their mascot. Now, they left us some wonderful photos of which you may see in front of you. And I must admit that when I did this submission, the photos just said interior of Rangariri Church. And I thought to myself, I must go and prove that. Where did they get those photos from? Well, the Auckland War Memorial Museum has an album, and I now know that this photo is the interior of the Rangariri Church that was partly demolished by cannon fire. But the one that I've put, please, if we can change it later, is actually of the Taupri Church, and I'm sure that will be very interesting to Taupri people. The other little photo is of the little Anglican church that was right beside the cemetery, and you can see that it was taken in 1863, very sadly, the day that they were burying their dead. So this whole area needs to be known as, for the whole of New Zealand needs to know the story. And if you don't agree to having some sort of a heritage area, we could end up with some other type of architecture that doesn't have any relevance to the history of this area. So we have been fortunate that council in the past have helped us to put a storyboard inside the village, outside the cemetery. And Tainui have got their fabulous symbolic path and do a wonderful job with their tours. But we mustn't forget the British soldiers. They were here too, and they are buried in that little cemetery just across the road from the hotel. Talking to the CEO of Hamilton Waikato Tourism last week, they also believe that it is a significant area with a lot of potential. So please, council, acknowledge this.
Thank you, Ms. Madsen. Ms. Kelly, I think you wanted to
Yes.
talk to your other submission, so fire away, please.
Right. As I mentioned at the beginning, these submissions were written in 2018. And I'm just bringing to note that the words archive or archives do not feature in the plan's chapter on heritage. After the launch of the Waikato District Heritage Strategy and its Heritage Forum in 2014, by February 2015, it was agreed that the major need was for a central district repository for the scattered heritage and community archives. Christine has just demonstrated how important it is to have such things accessible. We're very lucky in the libraries we have in Hamilton, Auckland and Wellington in particular. Waikato District must rate as one of, if not the worst, local government association for access to archives, both your own legally required and heritage or community archives. I list here. The personal intrinsic worth of validating a great-grandparent's existence through a photocopy book or listing is profound. In the years since 2014, area representatives whose collective knowledge equates with that of paid consultants have spent hours of voluntary time attending unproductive meetings. Paid staff have also wasted hours. Politically correct sheets of goals and actions have been produced, as well as screeds of minutes. Despite a visit to the Treasury, an exemplary archival repository in Thames a couple of years ago, it has taken until 2018 for a presentation by a Hamilton City librarian and its archivists to bring about the realisation of the specialist process required but lacking here. More democracy with respect for representatives, selective knowledge, rather than staff-driven bureaucracy might enable a wiser expenditure in this and other areas of responsibility. And I'd like to leave you all with this thought. Democracy is supposed to be government by the people for the people, not about growing the bureaucracies.
All right, thank you for that. Let's see if there's any questions, please. Mr. Marg, let's start with you.
Not like a question, but I just want to thank the ladies for their contributions. Thank you very much.
Thanks, Mr. Marg. Ms. Gibb?
Yes, I'm just best to declare that the Waikato District Heritage Forum, I am actually a council representative on that.
Thank you.
And also the archive discussion, I think maybe Ms. Kelly has seen a response from staff that this is perhaps not the forum for that, but I do take her point that there needs to be some further discussion on that, possibly outside of the district plan review. And I'd like to thank everyone for bringing the significance of rangiriri to the attention of the commissioners. We all do know a lot about rangiriri, but I appreciate your passion and would like to see what we can do to support you in some way. So thank you.
Thank you. Ms. Tiaho?
Yeah, I just really want to reiterate what Councillor Gibb has just said in terms of acknowledging your passion for rangiriri. I agree, it is a really significant site for both Māori and Pākehā and the building of the nation. So I just really want to acknowledge the time and effort that you've gone to make your submissions and to appear today. Kia ora koutou.
Thank you.
Thank you. I'm not sure who to direct this question to, so feel free to pass it around amongst yourselves. But if you put the issue of the scheduling, if you want to call it that, of the town as a whole, can we just go through your understanding of those parts of rangiriri that are protected in one way or another under the district plan? My understanding is that the historic tavern is a scheduled building in its own right. Is that your understanding?
Well, I believe so, yes.
And the council are proposing that the cemetery gates and the surrounds are also scheduled. That's the soldiers and those fallen in the Maori Wars. Is that your understanding?
No, we don't know that, and certainly after listening to you talking about the setting, it's most important that we really find out exactly where that little church was.
Okay, we'll get some clarification of that in a moment. I think when we also look at the Maori sites of significance, which we haven't had a hearing on yet, but reading ahead in terms of the hearing that's going to be held on that next week, certainly the rangiriri pā and the battlefields are acknowledged as being sites of significance to Māori. So I guess what I totally understand the point about, a precinct as a whole, but I think it would be fair to say that some of the, or most of the really key elements that really are at the heart of the history of rangiriri are actually earmarked for recognition in the plan, such that the town can't go to hell in a handcart because someone wants to, build a condo development in the middle of the battlefield or on the power site, or bulldoze the tavern and those sorts of things. Do you accept that whilst the plan doesn't go as far as you would like it to, and I understand the point that you've made very clearly, it's not accurate to say, and I'm not saying that you are saying this, but to say that Rangariri's been overlooked in the plan would be an overstretch? Would you agree with me on that?
Absolutely not. There are, next to the British Army Cemetery is a residential site. It's zoned residential. It has a joint wall, historic wall between them. The owner of that site has the opportunity to put any cultural diverse building from anywhere in the world next door to the British Army Cemetery and the historic wall. I don't see that. I see that as being totally incongruous to creating an historic village that deserves reverence, and to say that the battleground is going to be acknowledged. Māori that come to me and I talk to, they say people fell all over the village. It wasn't a specific area. There was conflict through the whole town, down to the lake. There was down to the river on the other side. That was the whole idea, was Māori built from water to water across to stop the British Army getting into the Waikato.
I think they would say, though, I don't want to put words in their mouth, they would say that Rangariri is just one of the bastions of that, and that extended throughout the whole of the rohe of the tribe. Well, and we're going to hear evidence next week, because we've read it already, that the cultural setting of the river and its margins, which includes the town, are of fundamental importance to the identity and sense of well-being and everything of the tribe.
And
so
the reason that the Ministry of Education has specifically made our town part of the education curriculum, and I think we have a responsibility just with that to create and preserve and respect the history. And so I think as a group and a town, we don't want an opportunity for a different culture or experience to come into the town. We would like to retain it in the reverence of what it should exist as.
Okay. All right. Now I understand the point you're making. Thank you. Okay. I haven't got any further questions. Does the panel have any further questions of the submitters? Well, thank you.
Well, I was interested just to make sure perhaps the Heritage New Zealand people could let us know whether the actual cemetery arch has New Zealand. I don't think it has a specific Heritage New Zealand protection on it.
I stand to be corrected, but I thought that, and I don't know about that aspect, but perhaps Dr. McEwen can help us. Can you perhaps very briefly just explain to us what the status, both in terms of Heritage New Zealand protection and what you're recommending in the proposed district plan for protection, what the status of that is, please?
Certainly. As you said, Mr. Chair, the Rangariri Hotel is already scheduled on the operative plan, and that will be, it's included in Schedule 30.1. I recommended for inclusion the cemetery arch and boundary wall, and I've recommended that for an A ranking in the proposed district plan. And as we've already discussed today, any pre-1900 site that may provide evidence of human activity is protected under the Heritage New Zealand Pohere Taonga Act of 2014. So and in a place like Rangariri, those archaeological resources, if you will, pertaining to the pre-war as well as during the Waikato War and subsequently up till 1900, are highly significant, and they have protection under the Heritage New Zealand Act. The Heritage New Zealand doesn't list the cemetery arch and wall, but as they've said in their submission, they rely on the district plan for protection.
Thank you.
Okay, that's helpful, at least to the panel. Thank you. All right. Well, I think we've exhausted all the questions we would ask of you. I just reiterate that we've got a long process to go before we make any decisions on any aspect of the plan. So you won't be hearing from us anytime soon, but you will be hearing from us in due course, and we've benefited from the submissions that you've made, so thank you for them. And as per the others, you're welcome to stay or welcome to go, just entirely over to you. So thank you very much. I think we'll press on. Ms. Greensill. Is Ms. Greensill still there?
Yes, kia ora.
Oh, there you are. Sorry. My apologies. There you are. You are there.
Yeah, sorry, I don't have a camera, and audio here is much better, so I'll just, I won't take too long.
Thank you.
Kia ora, Mr. Chair and fellow commissioners. We've supported the objectives and policies in the Historic Heritage Chapter. I'll leave my comments I made about areas of sites of significance for next week, for the next hearing.
Yes, no, that's fine.
I want to focus on the notable trees. The schedule on page 30, the schedule 30.2, page 4, lists the notable trees in Raglan. I'm not sure if you've got that anywhere there.
I'll just bear with me. I'm happy to get it up on the screen. It's just going to take me a minute. I've got to shuffle screens around. So, and why is that doing that to me? You can probably hear the music ringing, so I don't know why it's doing that. So I'll close all of that. There we go. I'll only be a moment. Hopefully I can, what is it you'd like me to show on the screen? Schedule?
Just the schedule.
Schedule
page
30.2.
Page 4, numbers.
Okay, just give me a second. As you can appreciate, it was probably the largest Section 42A report we've received thus far in multiple volumes. So I've just got to go through my file here and extract the right one.
It's probably not important. It's just
no. Well, I would like to give you the opportunity to talk to it. I've now got. It's interesting. 1, 2, 3, 4. Tell me if this is the right page.
I need to make that bigger so I can read it.
I'll make it a bit bigger. Does that look like the right page? That's scheduled. I think that's schedule 30.2. Someone correct me if I've got that wrong.
Page 4, notable trees. Okay, I must have a different version to use.
Well, we might be looking at at a different document.
Okay, it's well now that you've got the alterations, it's probably more different page. It's a Raglan. There is a list of Raglan trees.
Okay, let me see if I can just Gordonton, Ngarawahia, Newstead, Raglan. There we go. There's some from Raglan.
Right.
Where are we? There we go. Starting from here, is that right?
That's at 113, the old 113, down to about 130.
Okay, we can flick the pages as we go. So you just tell us what you want to refer to.
If we flick the page the next page.
Yep. Here we go.
Okay. Right. There's a couple of Pahutakawa trees there, 500th and 100th, and I'm just wondering what that means. I'm presuming that someone's planted that many trees.
These two here?
Yeah. Is that what makes them notable?
I'm not sure what 500,000 1,000th tree means.
Yeah, because what
Mr. Searle or Mr. Garden might be able to help us there, or Ms. Morris.
Thank you, Mr. Chair. I can clarify that it's Whangaroa Harbour-Kia. Is it?
Okay, so yeah.
Sorry for the pronunciation.
That's okay.
Okay, so
500,000 and 100,000 tree they planted.
Okay.
And are these little wee fellas at the moment, are they, that have been planted recently, or are these sort of notable in terms of their size and things already?
No, they're only juvenile trees as far as how it goes, but if you have any recollection of the pine tree on One Tree Hill, well, they represent the same sort of form because they're planted on Wainui Farm, on the crest of the hill, and they're very windswept type species.
Okay, no, that's helpful, thank you.
Yeah, no, I was wondering about that because we've actually planted pūtikawas that are probably not numbered in those numbers previously. What I'm wanting to do is include some trees in the list. One of them was a pūtiri, and I thought it was actually there. Pūtiri at 140 Whanga Road. Or is it 46 Whanga? No, 140 Whanga Road. Is there any tree?
Let's go back on the. Can't see it there.
Okay, in the previous plan, it was actually listed. It's a white flowered pūtiri tree.
Pūtiri, yeah.
And it's the council did some recent road work out there. We went out with them and made sure that they went around it. I mean, it's quite tempting, I think, to kill it so that the road can be widened. But it's a marker tree. It's a specific tree that we want protected and to continue having protection. So it's been removed from the list, and I'd like to put back.
Could you just, without going back to your written submission, because I've got the other one on the screen, makes it a bit hard. Can you just give me it's a pūtiri tree, it was in the operative plan, it's a marker tree, and it's located where?
It's located at 140, it's on a bend, 140 Te Whanga Road.
Te Whanga Road, okay, thank you.
So that's that one.
Does that ring any bells with council staff while we're out? If you're happy with Ms. Greensill, it might be helpful to canvass these as we go so that you get a technical answer from the staff if they're able to provide one. Are you happy with that?
Yes.
Or do you want to carry on?
No, that's fine. Yep.
You're in the hot seat, Mr. Searle. Any knowledge of that tree?
Yes, I have knowledge. There was, by all accounts, there was 2 white flowering puri trees. We could not identify either in terms of being a white flowered puri tree, but I have recollections of the particular puri tree the submitter is talking about on a sharp bend of Te Whanga Road.
Yes. So that's the tree. That's one. That mightn't be the white one, but that's one tree. The other that is not listed, and again, this has just become urgent again. It's on the side of a road on a sharp bend, and this pūtiri tree is at 656 Wainui Road.
Sorry, what was that, 656?
656 Wainui Road.
Yes.
Now, this tree, a couple of months ago, an entranceway was built off Wainui Road. The pūtiri is a marker between 2 hapu, Ngāti Haunuku and Ngāti Te Ikonahi. And it could have been felled to provide better visibility along the road, but we were fortunate that the operator was experienced enough to suggest cutting out a couple of pungas instead. So it really needs protection. It's hundreds of years old, and it's always stood in that particular bend.
You familiar with that one, Mr. Searle?
No, I'd have to do a bit of research into that one, Mr. Chair.
Okay, thank you.
It's just past Solscape. If you go around the corner by Solscape, there's a bend just down the bottom of the hill, and I think council have been probably it still belongs to the Haunuku family, so they own that part of the road that everyone drives over.
We just have to check that it's in the operative district plan in the first instance.
It's not in the operative district plan. What I'm asking is, because this incident has arisen, and 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 because this incident has I would like that tree added as a notable tree. It's more notable than something that's just been planted. It's been there for hundreds of years, and I think this is the appropriate time to try and put it in as a notable tree. So that's the request that I've been asked to put. Yeah.
With your approval, Mr. Chairman, we would need to go and evaluate the tree itself.
Yeah, well, let's come to where to from here later on. But thanks, Ms. Greensall. Let's keep going.
Okay, and the only other tree, and again, this tree is not on any road. It's a tree that's notable but has never been listed in the schedule, probably because we believe we can look after it ourselves. However, I think because it's an important tree, it needs to probably be listed. It's a Pahutikawa tree at 46 Te Whanga Road. It's not on the road, it's actually on the foreshore. And it's an important tree that dates way back to the time of Tāwhao, who lived there with his 2 wives, an ancestor of Tainui people. And it's a place that's, I guess it's a continuing reminder of those that have gone before us. So it sits on the foreshore. It's not in any danger at the moment, but I think it probably needs to be acknowledged as a notable tree.
Did you say that was at 56 Te Whanga Road?
Whanga Road.
Yes, 56?
46.
46, thank you.
Yes.
Okay, thank you.
Excuse me, Mr. Chair. I notice on that schedule there is crossings out on items 143 and 144 of white flowered puriri on Whanga Road, Raglan.
143.
144. It's down underneath where it says
sorry, here we go.
But like if we carry on past Tamaheri.
Oh, there we go. There we are.
That might help Mr. Searle, perhaps.
Okay, so 140, we want that reinstated. It may not be white puriri, but it is a puriri tree.
Without going back and checking the record, can someone from the staff remind me why that's got a red line through it?
We've assumed it was a double up, and as previously mentioned, we were unable to identify specifically a white flowering puri tree.
Okay. All right. No, that's okay. We'll talk about what we might do about that when Ms. Greensill's finished her submission. So let's keep that live.
So basically, that's all I wanted to add. Those, if we can have those protected and noted as notable trees.
All right.
I think our tribe will be happy.
Okay, that's very helpful. Thank you. Could I just ask? I guess Mr. Searle probably in the first instance. Is that something that you're able to liaise with Ms. Greensill about, in terms of identifying the specific trees that she's referring to? And then obviously it's up to you to make your recommendation as to whether they're notable or not. That's, I suppose, you're at liberty to form your own view. But can you liaise with Ms. Greensill and get back to us on that? And we'll talk about in the wrap up about how we might do that and when we might do it. But in principle, that's okay?
Yes, by all means. Yeah, definitely.
Excellent.
Very helpful.
All right, that's great.
Thank you.
So,
thank you, Ms. Greensill. That was very helpful. Thanks.
Thank you.
And we'll see you next week.
Thank you.
As per the others, Ms. Greensill, feel free to stay. Feel free to go and do something something else as you wish.
Thank you very much.
Thank you.
Bye.
Isabel, sorry for calling you by your first name, but I can't see where I wrote down your surname when you introduced yourself before, so my apologies for that. But I understand you're going to talk to us on further submission 1043 regarding the Tiuku Memorial Hall. Is that right?
Yeah, that's correct.
That's an excellent start. Could I just get your name again, please? And I apologise for having to ask, but I didn't.
Stop sharing screen, please.
Oh, right. Yeah, hang on. can only do.
Thank you.
I'm a man. I can only do one thing at a time. I was writing down your name. Hold on. Here we go.
Oh, that's good. So I can see you. All right. Okay.
So your surname was, sorry?
So I'm Isabel Hope, HOPE. Yep.
Thank you.
So, kia ora everyone, and Mr. Chair, I am a member of the committee of the Tiuku and District Memorial Hall, and so I'm speaking on behalf of everyone. We received a letter from Heritage New Zealand saying that this place is not included in the proposal Waikato District Plan schedule of historic heritage places, but as part of the Heritage New Zealand War Memorial Heritage Project, it has been identified as a meriting inclusion in that schedule. We were a bit confused about all of this, and then we thought maybe the reason is that we do have 2 rolls of honours in the hall from the First and the Second World War. So I would like to talk about this hall because I guess you don't have a written submission. So if you don't mind, I'm just going to read what I prepared. So this hall is known as Tiuku and District Memorial Hall as a carryover from the first hall, which was entirely funded by the local community in 1919 in recognition of the sacrifices made by local men from Tiuku, Waitutuna, Aramiro, Koroa and Okiti who went to war, and those who stayed behind and kept the country going as it was as a meeting place for the community. It was solely community recognition of those who served, and no other body made any contribution. When the original hall needed to be replaced, the existing hall was built entirely funded by the community and opened in 1968. The community raised funds and donations were made, and the hall was rebuilt by the people of the community, giving their time and resources. And in 1969, the building was freehold. Since then, the hall has been maintained and very well looked after and managed by the community with no contribution of funding from any other body. The community enjoys a range of activities proposed or offered and are very grateful to be able to use the facilities. The hall usage, meeting of legal obligations and maintenance has been self-sustaining over this period of time. The hall committee has a duty to the community to retain the hall status and preserve what has been achieved by the community. The community doesn't see any benefit of the heritage status. No legal agreement has been submitted for a viewing. Even if Tiuku and District Memorial Hall has some heritage value, the committee reached an unanimous decision to oppose the heritage status proposal. And to conclude, I'd like to say that while the committee recognises the significance of the rolls of honour and respects their importance, heritage status, there are definite complications in agreeing to the building being registered as a whole, and the memory of those community stalwarts who worked so hard to secure a freehold building must be honoured also. Basically, we've done very fine over 100 years. The community has looked after that building. We keep it going. It's in very good state, and we don't see the benefit of being heritage status. Thank you very much.
All right, thank you, Ms. Hope. Let's see if there's any questions. Let's start with you again, Mr. Marg.
Nothing from me, Mr. Chairman.
Thank you. Ms. Tiaho?
No, it's a very clear question, and I'm looking forward to the response.
Ms. Gibb.
No, I'd just like to see where we get with this. Thank you.
Can I just ask, who owns the hall and who owns the land it's on?
So it's owned by the community. So it's a Tiuku and District Memorial Hall Committee Incorporated. So it's totally community owned.
So it's owned by an incorporated society?
Yes, yes, it is.
Okay, thank you. All right, we've obviously got to, we don't make decisions on the hoof. We'll have to consider what the staff have said in their report and your submission, and as per the others, it's going to be a little while before you get any response.
Mr. Chair, I understand that you don't have a written submission. Would it be possible for me to send my submission in writing to you?
We've got a copy of your submission on the plan, which is further submission 1043. So we have that. If you want to send your speaking notes through to Mr. Bell, then that's fine.
Okay.
No, we do have your submission.
Okay. No, that's fine. Okay.
Thank you. Thank you very much.
Thank you.
As per the others, you're welcome to stay, welcome to do whatever else you feel you might need to do during the day. So entirely over to you.
Yeah, no, that's fine. Thank you very much.
Thank you. Which brings us to the end of the submitters that we're due to hear. There's been a range of things that have arisen, I guess, during the day. Normally, we just now ask the staff to reply. Quite a bit of what we've talked about are probably matters of detail that don't necessarily lend themselves to, you know, a rapid fire response. So just we're open to suggestions really as to what you would like to suggest to us.
Thank you, Mr. Chair. I actually am in agreement with you in terms of we've actually canvassed a lot of information today and time would be beneficial for that. There's probably two key elements being splitting the built heritage matters, objectives and policies, rules, and the tree schedule. And I think the tree schedule timing, there's probably a decent amount of time required for the guys to actually go and do the analysis that's needed, particularly now that they have to also go and have a look at some additional trees as per the Tainui o Tainui evidence we received today. I think also in terms of the built heritage, in addition to the objectives and policy and rule, just refining, ensuring that there is accuracies and ensuring that there isn't that matter that you've raised a couple of times today about unintended consequences, that also we need to do probably a little bit of forensic work on that just to ensure that is the case. And that dovetails with Dr. McEwen, just revisiting all of the heritage records to ensure that we've got the setting as per the intended position and making sure that everything aligns. So I'm sure your next question to me would be how long will that take? So I'm just going to glance around the room if you don't mind.
I didn't read mind reading was didn't know that mind reading was one of your skills.
Oh, as a planners in here, that's right. It's you know, us planners. I just asked the the arborists would like 5 to 6 weeks if that's possible, and possibly you know, it would probably be better if we all pulled that together into one package for you, because otherwise you'll be bombarded with bits and bobs out of this. So if we worked on a 6-week period for the whole package to be sent back to you, as
Yes, I'm away for 2 weeks.
Panel got any views on that?
Fine by me.
What is the work that the arborists have got to do that's going to take 6 weeks? Because there's 3 trees they've got to go and look at Raglan with Ms. Greensill. What are the other things they need to do?
So as I outlined in the opening, and that was reiterated in Grant's statement as well, there is a clear indication that the schedule as it is presently in the proposed district plan, and then although amended in the 42, there are still a number of inaccuracies that need quite a lot of detail.
I was aware of that. I guess we're keen to, whilst we're not in a desperate panic, we're also keen to get things done while they're front of mind, rather than sort of drift out and then we get to 6 weeks and no one's quite got round to it because something more pressing's come along. So I think we'd be happy with 6 weeks, provided it's a we wouldn't be keen on any extensions, let's put it that way.
No.
Does that make sense?
Yes, and the feeling in this room is that we don't want to labour this any longer either.
No, that's good. So if we called the end of this week, the first, so we go 1, 2, 3, 4. How about we say by Friday, the 4th of September, which is 5 weeks from Friday.
Doable?
Yeah. Yes.
Agreed.
Is that okay? I mean, if it's not, don't say it is when it isn't. But
I'm trying to dedicate my days to getting
it's only 2 working days short of 6 weeks.
Yeah. Is that doable for you, Anne? Yeah. Yes. No, we can all collectively work to that deadline. Thank you very much.
That's great. Thank you. What do we say? Friday, 4th September. I don't think we need to record anything more formally than that. We expect the council to reply. It's too complicated to do on the hoof. I think everyone accepts that. So I think we can just adjourn on the basis that, that we'll hear back in that time frame. And if we need to, so we'll adjourn now. If there's anything that arises from that information that we think either raises fairness issues with other parties, or we've got questions of, we can reconvene for the hearing, although I suspect that's probably fairly unlikely.
I'm going to stop the recording now, Phil.
I'll just double check. Is there anything anyone wants to say before we adjourn? Because I'd like the panel just to hang on for a second when we're done, including everybody on the call other than the 42A report. They don't need to stay, not because it's a secret society, but they don't need to.
They have to wait, sorry. And there's deliberations.
All right, so I think we're done. So thank you, everybody. Thank you particularly to the 42A report authors and contributors. It's been a massive task getting to where you've got to. It's not quite finished yet, but certainly what you've provided up till this point has been very helpful and we're grateful for it. So thanks.
Thank you.
And on that basis, we're adjourned. Thank you.